seeing a revival of the said land question? Professor Aketch.
You could call it a revival, but for me it is a country refusing to deal with a problem from inception. And inception, we need to go back to the year 1895.
That far back?
That far back, when Kenya became a protectorate of the British. And when the British declared that they were going to alienate certain lands. Alienate meaning they were going to take possession and ownership of land that they felt the natives, and I use natives in quotes, the Africans, were not using. They decided that certain lands were not being utilized economically and therefore needed to be converted to, economic uses. And so they took the land, irrespective of who owned the land at the time. And that is why, for example, we have the perennial Maasai land question. Unfortunately, we then decided in the 1950s that we were going to carry out what were called land adjudication processes. In other words, we were going to use the English system of ownership to determine who owns what land in an African setting. And that then created all kinds of problems, because you had people that did not own land or did not own all of the land, because when you're talking about land ownership, it relates to very many things. Mm-hmm. We talk, when I teach property law, I talk of property rights as a bundle of rights. So in the African setting, no one really has control over the entire bundle. It's usually a bundle of 9 or so rights. So some is just to use, some is just to take fruits from it, but you can never, in the African setting, it was very rare that somebody could actually have the right to transfer that land. But
wait, question, is this what we refer to as community land?
Community land.
Uh-huh.
Yes, so it's community because it is owned. Different individuals in the community have different rights to the same land. But so the English come and they introduce a completely different notion of property, which says that one individual can have everything, all of those, everything in that bundle. They can control everything in that bundle, including selling the land. And so they came up with a process of adjudication, and then we have to determine who owns this land.
This was in the 1950s? In the
1950s, you know, and this is around the Mau Mau times. So the Mau Mau have gone to war. Somebody is busy adjudicating and determining who owns the land, when the real owners have gone to battle. The real owners come back and find their land has been taken. Something happened in the coast, and this was through the Land Titles Act. And so, and part of the challenge is ignorance, because you see, you're dealing with an alien system. People don't understand that actually what is going on now through this adjudication process will then make someone owner of some land. So some people were not even aware, did not participate in it. They wake up someday and they're told this land belongs so and so. And so you find people that are squatters in their own land. And so that is a fundamental problem that we've had. And then we said the country refused to deal with it. At independence, the British then say, we will give you a constitution. We did not participate as citizens in this constitution. And in this constitution, we will protect existing property rights, irrespective of how they were acquired. Mm-hmm. So you've already created an injustice. Mm. Because you're already saying that the British took away your land, gave it to someone else. This someone else now has rights that are protected, and they're going to be protected by the Constitution. So an injustice is already established. How then do you deal with it? And then the British were also very clever. They said, how do we retain this system? Let's create an African landed gentry. And how did they create the African landed gentry? They said, let us govern through chiefs, the native chiefs, in terms of how governance works. So when they said, well, now we want to leave Kenya, to preserve our own interests, we're going to create people, we're going to give property to people that will protect our interests. Who are the people that are most likely to protect our interests? It is the native chiefs and their scions. And so you had a system where the native chiefs' scions, I mean, their children were being sent to the Oxfords, the Cambridges of this world. They come back and they're the rulers of Kenya. And then the people that much of this property is also transferred to. Willing buyer, willing seller. They say, but we have given it to these people by a process of law. And so they come back and say, but we have acquired this land legally. The Constitution protects our rights. And so that problem is perpetuated. And then in the 2000s, we then decide, let's have a land policy. Let's try and deal with this question of historical land injustices. And so we have a very elaborate, if you look at the National Land Policy of 2009, it has very, very good provisions on how to deal with historical, what we call historical land injustices. Unfortunately, this then does not find its way into the Constitution of 2010. And so if you look at the Constitution of 2010, it is very hazy on how you deal with the land question. In fact, it's just kicking the way you kick a problem that you don't want to deal with, you kick the back,
yes,
kick it forward. And so it continues. You kick it forward. Nobody wants to deal with it. And then remember that you have to deal with these landed gentry. They still exist. They're the people that own the largest ranches in Kenya. And I can tell you from my experience that they were the biggest obstacle in getting this problem solved, the land question. And they succeeded in ensuring that what was intended in terms of what we said, this is how we deal with the land question in the National Land Policy, it never found its way into the Constitution. And so you have today, you will see, we created the National Land Commission, and part of it was to say, let us give the National Land Commission the task of dealing with historical land injustices. Again, if you look at the National Land Commission Act, we are still kicking this bucket forward. It is saying in section 15 that within 2 years of its appointment, the Commission shall recommend to Parliament appropriate legislation to provide for investigation and adjudication of claims arising out of historical land injustices. Has it done that? No, it has not.
Just read that section again. Section what of the National Land Commission Act?
Section 15.
15,
The Commission shall within 2 years of its appointment recommend to Parliament appropriate legislation to provide for investigation and adjudication of claims arising out of historical land injustices. Nobody wants to deal with this problem.
Okay.
Yes.